Hello everyone, welcome to another video in our 4 slides polity series. In the last video, we covered the preamble to the Constitution. I would leave a link to that in the description below as well as you can access it in the card above. One of the important points to note in that video was that yes, the preamble can be amended by the Parliament as long as it doesn't alter the basic structure of the Constitution. In fact, the Parliament can amend parts of the Constitution without altering the basic structure. But what is this basic structure of the Constitution? This is often a difficult and confusing topic, so I will elaborate and explain about the basic structure concept in this video, and as usual, all in just 4 slides. This video consists of the following 4 slides. 1. The background and context to the basic structure doctrine. 2. We will then take a look at the important historical cases related to the basic structure doctrine. 3. We will thereafter understand the elements that constitute the basic structure today. And lastly, 4. We will answer a few important clarifying questions and conclude. So without further ado, let's dive into it. So what is the basic structure doctrine? The basic structure doctrine is an Indian judicial principle that the Constitution of India has certain basic features that cannot be altered or destroyed through amendments by the Parliament. The doctrine thus forms the basis of the power of the Supreme Court to review and strike down the constitutional amendments and acts enacted by the Parliament which conflict or seek to alter this basic structure of the Constitution. However, the basic features of the Constitution have not been explicitly defined by the judiciary, and the claim of any particular feature of the Constitution to be a basic feature or not is determined by the Supreme Court in each case that comes before it. Thus, it gives additional power to the Supreme Court to review and strike down any constitutional amendments or acts enacted by the Parliament. So the main points to note here are that the basic structure has not been explicitly defined by the Supreme Court. However, it takes up each basic feature that comes before it on a case-by-case basis. Through these various cases, the Supreme Court has invoked the principle of basic structure, and these cases provide us with a list of features that form the basic structure of the Constitution, as we will see in the forthcoming slide. Here we will examine the important historical cases related to the basic structure doctrine. The first was the Shankari Prasad case of 1951. In this, the constitutional validity of the First Amendment Act of 1951, which had curtailed the right to property, was challenged. The Supreme Court ruled that the power of the Parliament to amend the Constitution under Article 368 also includes the power to amend fundamental rights. The word law in Article 13 includes only ordinary laws and not the constitutional amendment acts. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a constitutional amendment act, and such a law will not be void under Article 13. However, in the Golaknath case of 1967, the Supreme Court reversed its earlier stand. In that case, the constitutional validity of the 17th Amendment Act of 1964, which had inserted certain state acts in the 9th schedule, was challenged. Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence the Parliament cannot abridge or take away any of these rights. A constitutional amendment act is also a law within the meaning of the Article 13, and hence would be void for violating any of the fundamental rights. The Parliament reacted to the Supreme Court's judgment in the Golaknath case by enacting the 24th Amendment Act of 1971. This act amended Articles 13 and 368. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and that such an act will not be a law under the meaning of Article 13. However, in the Keshavananda Bharati case of 1973, the Supreme Court overruled its judgment in the Golaknath case of 1967. It upheld the validity of the 24th Amendment Act of 1971 and stated that the Parliament is in fact empowered to abridge or to take away any of the fundamental rights. However, at the same time, it laid down a new doctrine of the basic structure or the basic features of the Constitution. It ruled that the constituent power of the Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. Now let us briefly discuss the Sardar Swaran Singh Committee and the 42nd Amendment. Soon after the declaration of national emergency, the Congress Party had constituted a committee under the chairmanship of Sardar Swaran Singh to study the question of amending the Constitution in the light of past experiences. Based on its recommendations, the government incorporated several changes to the Constitution, including the preamble, through the 42nd Amendment passed in 1976, which came into effect on January 3, 1977. Among other things, the amendment gave the directive principles of the state policy precedence over the fundamental rights contained in Article 14, like right to equality before the law and equal protection of the laws. Article 19, various freedoms like freedom of speech and expression, right to assemble peacefully, right to form associations and unions, right to move about and reside freely in any part of the country, and the right to pursue any trade or profession, as well as Article 21, right to life and personal liberty. Article 31C was amended to prohibit any challenge to laws made under any of the directive principles of state policy. The amendment also laid down that amendments to the Constitution made in the past or those likely to be made in the future could not be questioned in any court or any ground. It also removed all amendments to fundamental rights from the scope of judicial review, and it removed all limits on Parliament's power to amend the Constitution under Article 368. However, within less than 2 years of the restoration of Parliament's amending powers to near absolute terms, the 42nd Amendment was challenged before the Supreme Court by the owners of Minerva Mills, a Sikh industrial firm which was nationalized by the government in 1974. In this case, the Supreme Court affirmed judicial review as a basic feature of the Constitution. We've talked a lot about the historical context of the basic structure of the Constitution. But what are the elements of the basic structure? The present position is that Parliament under Article 368 can amend any part of the Constitution, including the fundamental rights, but it cannot affect the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. Some of the features of the Constitution termed as basic are given here, such as supremacy of the Constitution, sovereign, democratic and republican nature of the Indian polity, secular character of the Constitution, separation of powers between the legislature, the executive and the judiciary, federal character of the Constitution, unity and integrity of the nation, welfare state, judicial review and the powers of the Supreme Court under Articles 32, 136, 141 and 142, freedom and dignity of the individual, parliamentary system, rule of law, harmony and balance between fundamental rights and directive principles, principle of equality, free and fair elections, independence of judiciary, and limited power of the Parliament to amend the Constitution, as well as powers of the High Courts under Article 226 and 227. These are some of the elements of the basic structure of the Constitution. In today's context, it may be said that the final word on the issue of the basic structure of the Constitution has not yet been pronounced by the Supreme Court, a scenario that is unlikely to change in the near future as well. While the idea that there is such a thing as basic structure to the Constitution is a well-established fact, its contents cannot be completely determined with any measure of finality until a judgment of the Supreme Court spells it out. Nevertheless, Sovereign, democratic, and secular character of the polity, rule of law, independence of the judiciary, fundamental rights of citizens, etc., are some of the essential features of the Constitution that have appeared time and again in the apex court's pronouncements. One certainty that emerges out of this tussle between Parliament and the judiciary is that all laws and constitutional amendments are now subject to judicial review, and laws that transgress the basic structure are likely to be struck down by the Supreme Court. In essence, Parliament's powers to amend the Constitution is not absolute, and the Supreme Court is the final arbiter over the interpretation of all constitutional amendments. This concludes our video on the basic structure of the Indian Constitution in 4 slides. If this video helped you in any way, please don't forget to hit the like button. As ours is a small channel just starting out, it would really mean a lot to us and it would help us out a lot in the long run. And if you want to stay updated on these videos, please subscribe to the channel. That way you won't miss out on any future videos. Happy learning and thank you once again.